always.
Yeah, chapter.
10th May to 10th June होता है हमारा वहाँ.
Shall we start on one?
Yes, we can start, no problem.
Good evening, one and all. And once you have Mr. Aseem Pandya, a senior advocate and a former president of the bar, you would know that the knowledge would automatically flow. We have done various sessions with Mr. Aseem Pandya, and I can say with some sense of confidence as well as exuberance that he takes a different perspective of law and it has a deeper insights of that. Today's topic looks so intertwined, but they have their own significance. And today's session is on will, nomination, probate, letter of administration, and succession. And I'm thankful that on a working day, the senior counsel has accepted our request to share his knowledge. Over to you, Mr. Pandya.
Yeah, thank you very much for the nice introduction. Today's topic, as you said, is about will, probate, succession certificate, and letter of administration. I must tell you that why I have chosen this subject. During my entire career as a lawyer, I have always found that Indian Succession Act is a very complex law. If we see the provisions of the Indian Succession Act, there are about 391 sections and there are 9 schedules attached to the Act. The most important and most complex part of this law is that you will have to find out that whether a particular part or a particular chapter or a particular section is applicable to Hindu, or it is applicable to Muslim, or it is applicable to Parsi or Indian Christian. So everywhere in every section, before you apply it, you please verify it first that it applies to whom. So there are chapters like intestate succession pertaining to Parsis, intestate succession pertaining to non-Parsis. Then there are chapters and there are sections where it says that the provisions of this section will not apply to Hindu, Jain, Buddhs, and Sikhs. So you will have to find out in every section, every chapter, whether this particular section or provision will be applicable to case on your hand, because whenever you come across a particular case, you will have to apply the provisions of law. And before you apply, you will have to be sure whether this particular provision will be applicable to your particular case or not. So this is a very fascinating thing about it. And I think since it was enacted during the British era, it essentially intended to cover the Christians who had come from Britain. And thereafter, while enacting this law, they have also covered certain aspects pertaining to Hindus, Muslims, Parsis, and Sikhs also. So first of all, I would like to make you aware of certain concepts under the Indian Succession Act. Of course, since you are all lawyers, you are aware of it to some extent, but to bring better clarity, it is necessary to understand these concepts. First concept is testamentary succession, and second is intestate succession. So what is testamentary succession? You are aware that when a person dies after making a will, valid will, then it is known as testamentary succession. But if a person who is deceased has not made his will or last testament, then it would be known as intestate succession. So throughout this entire act, these two words are used, either testamentary succession or intestate succession. So these two concepts are most important. Then what are we talking about? We are talking about testamentary succession. Then we must understand what is will. So the word will has been defined in section 2, subclause H, which says that will means a legal declaration of a testator whereby in respect of his property, which he wants it to be carried into effect after his death. So will is a legal declaration which is to be carried into effect after his death, and it is in respect of the property of the deceased. So this is the definition of will. Now, having understood the definition of the word will, the next question would be what is probate and what is letter of administration. The word probate has also been defined under section 2 of the Indian Succession Act. It means a copy of the will certified under the seal of a competent court whereby administration of the estate of the deceased is granted. So probate means it is a certified copy of the will and authenticated under the seal of the court whereby administration of the estate is granted. So probate, when we talk about, you must now remember that it is a copy of the will. So where will has to remain? That is a very crucial question which we must remember, because most of us are not aware of it. That whenever we apply for probate, the original will is to be preserved under section 294 of the Indian Succession Act by the court itself until the state government makes a law or provides a different registry to preserve the wills. So original will, if you have applied for the probate, is never returned, but it is preserved by the court under section 294, which most probably most of us are not aware of it. So this is a worth thing which you must remember, that probate is a copy of the will given under the seal of the competent court and whereby the administration is granted. Now next term is executor. Now who is executor? Whether it is necessary to appoint executor under the will, that we will examine when we will discuss about who is competent to make and what are the basic requirements of a valid will. But executor means a person to whom the deceased person by his appointment under the will given right to administer the estate, and it has been confided to the executor. So executor is a person who is to be appointed by will. If in the will a person has not been appointed as executor, then there is no question of appointing an executor by the competent court. So executor is a person definitely and certainly appointed under the will, and in him there is a trust reposed by the person who has made the will that he will administer the will in accordance with the wishes expressed in the last testament or the will. So that is known as executor. And the next concept is administrator, which is defined under clause A of section 2. Administrator means a person authorized by the competent authority to administer the estate of the deceased when there is no executor. Please remember it, that who is administrator? When court can appoint an administrator? Administrator can be appointed only when under the will there is no appointment of an executor. So keeping in mind this 6 concept: testamentary succession, intestate succession, will, probate, who is executor and who is administrator. Now let us begin with the important aspect of who is competent to make a will and what are the requirements of a valid will. As I said, that will is a legal declaration of the intention of the testator, which he wants it to be carried into effect after his death. So first requirement of making a valid will is that person who is making a will is competent and mentally fit to make a will when he is making this a particular will. So mental fitness is a most crucial aspect. Then question arises that whether a person who is deaf, dumb, or a blind person whether he can make a will or not, whether a woman is entitled to make a will or not. The answer you will find in Section 59 of the Indian Succession Act, which says that a woman is entitled to make a will in respect of her own property, because under Hindu Succession Act, under Section 14, woman has absolute right with regard to the properties which is owned or inherited by her. So woman is not incapacitated of making a will. The blind person, deaf and dumb, if they are capable of understanding what they are doing, they are also entitled to make a will. Then there is person who is uh, intoxicated or who is insane, whether they can make a will. The answer is that they cannot make will when they are under the influence of intoxication. They are unable to understand what they are doing. Only they are entitled to make if person is insane during the lucid interval. So it is the responsibility of the person who is making a will or who is the propounder of the will to prove that the will was made when there was a lucid interval. So every person who is a major adult person, because and a person who is minor is presumed to be not knowing what he is doing. So this is the presumption of law. So every adult person is entitled to make a will. Now, what are the requirements you are aware of? So I will quickly mention those requirements of the will. The will requires attestation by two witnesses. So first aspect is whether will should be typewritten, whether it should be handwritten, whether it should be registered, whether it should be on a stamp paper, whether it should be notarized. It is these things we must know. The requirement of law is that will does not require any registration. The will does not require notarization. It need not be on a non-judicial stamp. So even handwritten piece of paper, if it is attested by two witnesses who had signed, the testator signing the will, and similarly the testator must also see the person who is attesting witness signing the will in the presence of the testator. So basically, as I said, that there are no formalities attached to the will. It can be on a plain paper. You can write in your own handwriting also. So it does not require a particular kind of paper. It need not be typewritten. It need not be on a stamp paper. So only requirement which law insists is that it should be attested by two witnesses who had seen the testator signing the will. So this is what I am talking right now is about the unprivileged will. There is a concept of privilege will which we are not going to discuss today because we are not concerned with it. Privilege will can be made by the persons who is in army and who is fighting, or mariner, or person who is in air force when they are in the field. So there these formalities of unprivileged will, if that is insisted, that would not serve the purpose. Therefore, the concept of privilege will is also there under the Indian Succession Act, but we are not concerned with that. We are talking, when I talk about will, you should understand that I am talking about an unprivileged will. So these are the basic requirements of a valid will. Now, suppose after will is made by a testator and then he has some uh, change in the mind and he does interpolation, insertion, or incorporation with handwritten note, then whether those handwritten note or interlineation or interpolation or incorporation, whether they are to be treated as part of the will or not. The answer is that if it is not attested in the same way as in the case of will, the interlineation or insertion, interpolation would not be considered as part of will. So if somebody is inserting a line in the will with his own handwriting, then he has to put a signature in the side column. And similarly, two witnesses must also attest that correction or amendment in the will. Otherwise, whatever insertion, correction, amendments that are made in the will not be considered to be legal, and will be considered as per whatever originally done at the time of attestation. So this is the basic requirement of will, and as I said that if it is done, this amendment is done, it would not be valid unless it is attested in the same way. Now coming to the probate. Most of us are not sure that when probate is mandatory, or question is whether probate is mandatory in every case. The answer is no. In what cases a probate of a will is mandatory? You will have to refer to section 57, clause A and B of section 57, read with section 230. So only when the case is covered under section 57, clause A and B, read with section 213 of the Indian Succession Act, probate is mandatory if the person who is claiming right as a legatee or executor in the court of justice, then probate is necessary. So I must clarify this aspect, because we are under the misconception that whenever section 57 clause A and B is applicable, probate is mandatory. That is not correct. Probate is mandatory if you want to establish your right as a legatee or an executor in the court of justice. So if you do not want to establish your right, and if you are producing your will before the authority and authority accepts it, that is fine. But if there is a dispute among the legal heirs, or if somebody is questioning the right as a legatee or executor, then in that case, if such a dispute arises and if the legatee or the executor wants to establish his right in the court of justice, then only the probate in these circumstances is mandatory. And that too with regard to clause A and B of section 57. Now, let me just point out what is clause A and B of section 57. It says that if a person has made a will after 1st September 1870 within the territory of the Lieutenant Governor of Bengal, or within the territory or original jurisdiction of Bombay High Court and Madras High Court, then if he wants to establish his right as a legatee or executor in the court of law, a probate is mandatory. Second is that even if person might be staying or not domiciled in these three cities, but if the properties of that person is situated within the territory of these three cities, namely Calcutta, or I may not confine it to Calcutta, because the section says that whatever area which was situated on 1st September 1870 within the territory of the Lieutenant Governor of Bengal, or within the original civil jurisdiction of Bombay and Madras, then only the probate is mandatory. So please remember it, that on 1st September 1870, whatever area was covered, so whatever, suppose the city limits have been expanded, then whether clause 57A and B will apply or not. In my personal view, it will not, because the section itself says that whatever area which was there as on 1870 in these three territories, and property is situated or person is domiciled in these cities, then only the probate is mandatory if he wants to establish his rights as a legatee or executor in the competent court of justice. So this is the only requirement. Otherwise, in India, in other parts of India, the probate of the will is not mandatory. Only if there is a dispute and if the person wants to administer the property in accordance with the intention of the testator, then he may apply and If there is a contentious case, then he might apply for a probate to point out that will is genuine and it is certified by the court, and therefore genuineness of the will must be accepted. So please remember this very important aspect, that Section 57 read with Section 213 requires that if the will is executed in this territory or the property of the deceased is situated within these territories after 1st September 1870, then only probate would be mandatory when somebody wants to establish his right in the court of law. If the authority is accepting the will as it is, then there is no requirement. And you can also persuade the authority that there is no dispute. Nobody is disputing this genuineness of will. Why are you asking me to obtain probate? Only if one of the legal heirs or the person who is entitled to inherit the property, if he raise a contention about the genuineness of will, the authority should go by the will, execution of will, because it is executed in accordance with the provisions of the Indian succession in presence of two attesting witness. Then there should not be any difficulty in acting upon such a will. In my personal view, only when there is a contention, there is a dispute, then only in these three territories a person has to obtain probate. So now probate, when we talk about probate, please remember what does it mean? It is a certified copy of the will under the seal of the court whereby administration is granted. Now please remember one thing, whether you are an executor, whether you are an administrator, or whether you are a holder of the succession certificate. In all such cases, the beneficial interest in the estate will not go in favor of the executor or administrator or the person who is holding succession certificate. So beneficial interest of the estate would devolve as per the rules of inheritance of a particular religion. Suppose if a person is following Hindu religion, then actual succession has to be governed under the Hindu Succession Act. So they are merely legal representatives. So whenever in any suit or proceedings, a question arises, who is the legal representative of the deceased? Then if person has made a will and he has appointed an executor, then executor is the only person who is a legal representative of the deceased. Now suppose executor has not been appointed, then whether court can appoint an executor? The answer is no. Court cannot appoint executor. Court can at best appoint an administrator, and that kind of procedure is known as appointment of administrator with annexed will, because this is we are talking for the timing, we are talking about the testamentary succession. So when there is a will, so administrator can be appointed, letter of administration can be granted with the will annexed in favor of a person when there is no executor. So out of those qualified persons who are entitled to inherit the property of the deceased, any one or two person can jointly apply for the letter of administration. And if the court is satisfied with regard to their interest in the property, the court might grant letter of administration. So please remember it that probate can be granted to the executor only. Probate cannot be granted if there is no appointment of executor, or if an executor is appointed, but he has gone abroad, he is not available, or he has died before the testator died, or if he refuses to accept as an executor, to carry out the work as an executor, then only the court is entitled to appoint an administrator. So the second answer, you have coincidentally got it, that who is a person who can be granted letter of administration. So as I said, only in absence of an executor under the will, letter of administration can be granted to one of the qualified legal heirs or legatee, or one or two persons can apply for joint administration to the competent court. So this is, you must remember that when letter of administration can be granted. Now, third aspect, that is section 218 of the Indian Succession Act, which provides that if a person has not made a will and he dies intestate, as I said, that intestate means a person has died without making a will. So if a person has died intestate, then in that case also, how to administer the estate of the deceased? Because he has not made a will. Then in that case, if somebody, a legal heir, wants to administer the estate of the deceased, then he will have to apply for letter of administration. So letter of administration can be granted in two contingency. One, as I said, that if under the testamentary succession, the executor has not been appointed in the will, then in that case, letter of administration with the annexed will is granted. But when a person has died intestate without making a will, a simple letter of administration is granted by the competent court. So you please bear in mind this subtle distinction, letter of administration with annexed will and letter of administration simple. So when person has died intestate, any of the legal heir jointly or individually can apply for letter of administration. And once letter of administration is granted, he is entitled to administer the estate of the deceased. So this is a very important aspect we must remember, because sometimes after letter of administration is obtained and you go to the municipal corporation for changing the name in the property in the favor of legatee, and if you produce the letter of administration, the municipal corporation will insert your name as an administrator. They would not insert the name of the persons who is entitled to the estate as a legatee. So this creates a very awkward situation, because person who is given letter of administration has no beneficial interest. He is simply an administrator of the estate, and he has to administer the estate in accordance with the rules of inheritance of a particular religion. If you are following Hindu religion, then Hindu Succession Act. If you are following Christian religion, then a Christian Succession Act, or Muslim Succession Act, etc., etc. So the responsibility of the administrator or executor is simply to administer the estate of the deceased, and he will not have any right. But sometimes you will find that a person who has been appointed as an executor is also one of the legatees. Then in that event, what would happen? A person who is holder of the probate or letter of administration, whether he would be entitled to get his name inserted in the property card or municipal register. The answer is in, I think, section 233, 234 of the Indian Succession Act, where it provides that when the competent court has granted letter of administration with will annexed or a probate to the executor, or in the case of intestate succession, letter of administration simple, then in that case, while administering the estate of the deceased, the executor or the administrator have to give assent to give the property to a particular legatee in accordance with the desire of the deceased in the will, or if there is no will, in accordance with the rules of inheritance. So once he gives assent, so he has to give assent by express words, by in writing, or it can be implied, or it can be inferred from the conduct of the executor or the administrator. So once letter of administration is granted or probate is granted to the person, he has to administer the estate, and then he has to clearly give an assent. Once he writes a letter of assent, with the letter of administration, the corporation is bound to enter the name of the person who is as such entitled to get the property as a legatee, and in conformity with the assent given by the executor or the administrator. So this is a very interesting thing which we must remember, because most of us talk about the probate and letter of administration, but after the issuance of the letter of administration, what happens? What are the responsibility and liabilities of the administrator or the executor? And there is a time bound frame also, that within a particular time these persons will have to conclude their work of distribution of the estate in accordance with the intention described in the will or as per the rules of inheritance, and they have to report it to the court concerned about the completion of the work. So these things which probably we are not aware of it. So my endeavor is to point out certain very important aspects of the Indian Succession Act, which may not be, most of us may not be aware of it. So please remember this aspect also, that executor or administrator has to give his assent. And only once assent is given, they are divested of their position as executor or administrator. So thereafter, the beneficial interest would go in favor of the legatee or the person who is entitled to inherit the property in accordance with the rules of inheritance. So this is what you must understand. Now, question of succession certificate. Question, before we go to question of succession certificate, which court would be entitled to grant letter of administration or probate? So under the provisions of law, so far as probate is concerned, where the properties are situated, that district court will have jurisdiction to grant probate or letter of administration. So wherever part of the property is situated in one territory and part of the property is situated in another territory, both the courts will have jurisdiction, because the property is situated in the territorial jurisdiction of the district court. So usually district court is considered to be a competent court to grant probate or letter of administration. But please remember again, those three cities, namely Calcutta, Bombay and Madras, where by virtue of section 57A and clause B, it is mandatory to obtain probate or letter of administration if somebody wants to establish his right as a legatee or executor. So in those cases, the competent court is the High Court. So for these three territories, the High Court will have a testamentary jurisdiction. And in those cases, unless the government has issued a notification authorizing any other court to receive the probate application or letter of administration application, those district courts will have no jurisdiction. Otherwise, in rest of the country, entire nation, the district courts are considered to be the competent court to issue letter of administration or probate, or then when we talk about the succession certificate, also succession certificate. Now, whether this power can be delegated to subordinate courts or not, it depends on the provisions of the provincial statute. In many states, the district court has delegated such powers to senior division courts, and in that case, the senior courts will also have jurisdiction to receive the application for probate and letter of administration. Now, what is the nature of procedure? The nature of procedure, if it is a non-contentious issue, then it is simple. You will have to move an application for probate. You will have to give details that are mentioned in the provisions of law, that the name of the deceased, who are the legal heirs, when did he die, what are the properties, so description of the properties, etc., valuation of the property, etc. So that kind of application with due verification at the bottom has to be done, and it has to be presented to the competent court. Sometimes, if it's a non-contentious case, there is a provision for issuing probate by district delegate also. So power can be delegated to district. When non-contentious case is there, even district delegate can issue a probate or letter of administration. But if there is a contention, If there is a dispute, somebody is saying that this person is not a legal heir, I am the legal heir, or his share is this much, or my share is this much, or somebody is disputing the genuineness of the will, in that case, it becomes a contentious case. In such cases, the which is a summary procedure or a short procedure of issuance of probate, that will become a long suit procedure. So it is almost tried as a civil suit, and the person who is applying for the probate or letter of administration is considered as a plaintiff, and the person who is objecting to the issuance of letter of administration or probate is considered as defendant. So once there is a contention, there is a dispute about the entitlement or genuineness of will, etc., then in such cases it becomes a long cause suit, and it has to be tried by as if it's a regular suit. But only distinction is that after deciding the issues, either court issues the probate or a letter of administration, whatever is applicable. But in such cases, decree is not required to be drawn, because when we examine the provisions pertaining to appeal, revision or review, these provisions speak of the order passed by, order issuing probate or letter of administration, or refusing to give probate or letter of administration. So these are not in that sense, though the provision, once there is a contention, it partakes the characteristics of a ordinary suit. But at the end of the proceedings, either probate is granted, or a letter of administration is granted, or succession certificate is granted, or it is refused. But in that event, when the legislation has used the word order, the question of drawing decree will not arise. So please remember, this is also one of the important aspects. And as I said, that will is to be preserved by the competent court with it, unless and until the state government establish the registry for preservation of the wills. So this is the broad procedure of obtaining probate or letter of administration, and you have now understood letter of administration with annexed will and ordinary letter of administration. Now coming to the next point is succession certificate. Now succession certificate is sometimes confused with the heirship entry in the land revenue code, because under the land revenue code or land laws, whenever entry is to be effected, mutation entries, there is a requirement of preparing a family tree or succession entry. So in that case, whatever is given is not that succession tree which is contemplated under the Indian Succession Act. Please remember it that succession certificate cannot be granted for immovable property. Succession certificate is permissible to be granted in respect of the debts to be recovered on behalf of the deceased, or the investments made by the deceased in certain securities or shares, stocks, insurance. In those cases, if somebody wants to recover these things, debts or security, then in that case, only succession certificate is permissible to be granted. So succession certificate cannot, please note it down, that succession certificate is not to be granted in respect of immovable property. It cannot be granted in respect of other movable property, except the securities, stocks, investments, etc., which are liable to be recovered on behalf of the deceased. In respect of those debts and security, succession certificate can be granted. Now, why succession certificate provision has been made? When there is a provision for grant of probate, letter of administration, the succession certificate procedure is a summary procedure, which has been envisaged to see that this procedure can be simplified and it can be summarily be decided, and person who are the legal heirs are not deprived of whatever is due to the deceased. So there is a summary procedure prescribed, and therefore it has been contemplated that only in respect of dates or security succession certificate can be granted, and it has been clearly stated that the summary, the procedure which is adopted for granting succession certificate will be a summary procedure. This succession certificate is granted under Part 10 of the Indian Succession Act. Probate and letter of administrations are granted under Part 7 and 8, whereas the testamentary succession is covered under the Chapter 6 of the Indian Succession Act. So succession certificate, please remember it that it is only in respect of date and security. Now, what would be the court fee that would be applicable for succession certificate? The court fee will be dependent on the value of the investment or the security which you are seeking recovery from the debtor of the deceased. So on the basis of the valuation which is stated in the succession certificate application, you will have to deposit certain amount towards the court fees. So you will not have to purchase the stamp papers when you apply for the succession certificate. You will have to deposit with the court equivalent amount on the basis of your self-assessment. And if only if the succession certificate is granted, thereafter the stamp duty stamp is purchased and the stamp duty is collected. So this is a slightly different procedure which we are not aware of it. So in such cases, this is the procedure to be adopted. Now succession certificate also, like probate also, whenever you apply for petition, it has to be published at a conspicuous place in the court precincts, as well as a public notice is also required to be granted. And only after this procedure is followed, if there is contention, if there is no contention, further proceedings can be undertaken as per the provisions of the Indian Succession Act. So, one distinguishing feature between succession certificate and probate and letter of administration is that succession certificate has all India applicability. So once you get a succession certificate, it will apply irrespective of the territorial restrictions all over India. But so far as probate and letter of administration is concerned, usually it is granted within the state where the property is situated. But if the properties are situated in other states also, then there is a specific requirement that you must specifically state in your application for probate or letter of administration that I want letter of administration or probate in respect of the entire India. And it should not be confined to a particular state where part of the properties are situated, but I want its applicability all over India, because I will also draw your attention to the fact that succession certificate being summary, when competent courts grant letter of administration or probate, it supersedes the succession certificate. So succession certificate becomes irrelevant if in respect of the same date or security, entire estate, the probate or letter of administration is granted. So section 215 read with section 385 of the Act clearly provides that if succession certificate is issued under Part 10 in Schedule 8, as soon as the probate of the entire estate or letter of administration for the entire estate is granted to someone, it supersedes the succession certificate. This provision also most of us are not aware of it. And as I said that succession certificate has application all over India. Please remember what I said in the beginning. Whether you are holder of the succession certificate, or you are holder of the probate, or you are holder of letter of administration, it will not give you beneficial interest in the estate of the deceased. You are simply administrator. Even in the case of succession certificate, suppose you have been given succession certificate. On the basis of that succession certificate, you apply to a particular company that my father's held this many shares in this company and therefore now please transfer in my name. Now, suppose company transfers the shares in the name of that particular person who is holding the succession certificate. Then also, other legal heirs are entitled to claim as per the rules of inheritance. And mere grant of succession certificate would not divest the lawful entitlement of other legal heirs who are entitled as per law to inherit the properties of the deceased. So, all throughout, you will find that they are simply holding as a trustee on behalf of the persons who are legitimately entitled to claim the estate of the deceased. They do not become owner. Please remember it, neither the probate holder nor the letter of administration holder nor the succession certificate is the owner of the estate or the debt or security which is sought to be recovered. So please keep this in mind. And as I said, that letter of administration probate would supersede the succession certificate. Succession certificate, probate, and letter of administration can be cancelled or revoked in certain circumstances if it has been obtained by fraud, concealment of facts, or the procedure is defective. And so far as successor certificate is concerned, it can be revoked or cancelled if subsequent event has resulted in change of situation, like as I subsequently suppose probate or letter of administration, then also the succession certificate would lose its efficacy and it can be cancelled or revoked. But whatever amount has been paid by the debtors of the deceased or whatever investment has been returned to the succession certificate holder, that would be a proper discharge of the debts. It would be considered as a legal discharge of the debt, and the debtors are not concerned with the inter se rights among the legal heirs of the deceased. So it would give full indemnity and complete discharge of their liability towards the deceased debts and security. In any case, in the case of estate also, if there is a probate and estate, some properties are transferred in the name of a particular person as per the direction of the executor or the administrator, it would be a legal defense and it would completely indemnify the person who is transferring in accordance with the direction of the executor or administrator. So these are the main provisions. And now one last aspect is about nomination. So nomination also, you are all aware, the nominee is not a legal owner or beneficial owner. He is simply, the nomination system has been evolved to see that after the death of a person, the transfer becomes easier. So to facilitate the transfer of the estate or the security or investment in the name of the legal heirs, the nomination procedure is contemplated. So nominee is again a trustee, like succession certificate holder, letter of administration holder, or the probate holder. So they are all almost are sailing in the same boat. They have all same duties and same liabilities. So they cannot say that since I am named as a nominee, I am the person who is rightful holder of the property. So there are certain statutes. Recently in 2024, I think it is reported in 2024 4 SCC, page 642. The title of the case is Shakti Yazdani versus Jayanand Jayant Salgaokar's case. In that case, the Honorable Supreme Court was confronted with the situation where there are several statutes like Companies Act, and then Depositors Act, then Cooperative Societies Act, so on and so forth, where the provisions are made that everybody has to give a name of the nominee, that who would be ultimately entitled to get transfer of shares or the estate of the deceased after his death. And the language of such section was that property will vest in the nominee as such. So question was whether as such means whether beneficial interest of the property would be vested in the nominee, or it would be simply he would be holding property on behalf of all legal heirs in trust. The Supreme Court examined the scheme of all the acts and finally held that whatever may be the language of a particular statute, nominee does not become the beneficial owner. He is simply a trustee who is holding the property on behalf of all legal heirs who are entitled to inherit the property. And it is the responsibility of that nominee. And mere transfer of the estate or shares or stocks or investment in his name would not entitle him to sell or transfer or alienate, and he would be accountable and responsible to indemnify if he has sold it. Other legal heirs can recover the amount from him. So nominee is merely a trustee holding on behalf of all legal heirs. It is just a system of facilitating transfer after the death of the deceased. One more interesting aspect, which you must know it, was also posed before the Honorable Supreme Court in the case of Indrani Vahi versus Registrar of Cooperative Societies, which is reported in AIR 2016, Supreme Court page 1969. And you will all be coming across such a situation where under the Cooperative Societies Act of every state, there is a requirement that in the event of death, who would be the nominee? So nomination form, filling up of the nomination form under the respective state cooperative laws is mandatory. So once nomination is there, whether the society can refuse and whether society can insist that despite nomination, the person who is nominee should bring no objection certificate from the other legal heirs before the society transfer the name in the name of the nominee. The Supreme Court said that society, neither the society nor the registrar of cooperative society can say no to transfer because it is by a way of nomination, and the nomination has to be given effect to, because it is a system which is to facilitate transfer of the property. But only thing, as I said, that merely because it has been transferred in the name of nominee, he does not become the beneficial owner. So this judgment is crucial because you might come across such cases where I have also come across such cases where despite nomination given by the deceased, after the death of the person, when the person who is named as nominee goes for transfer of shares in his name, the society will insist that please bring no objection certificate on affidavit of other legal heirs. Please execute an indemnity bond that you will indemnify the society in the event of litigation. So this kind of practice, in my personal view, is absolutely contrary to the judgment in Indrani Vahi versus Register of Cooperative Societies. Once nomination is there, society has no authority to refuse transfer of shares in the name of the nominee. So I think with this, I have covered almost all important aspects about the letter of administration, probate, succession certificate, and the concept of will. And I think that most of us who are practicing in High Court, even in trial courts also, this kind of litigation comes rarely. And therefore, there is no occasion to look into the provisions of this Indian succession. In fact, I was also confused with this concept of letter of administration with annexed will and letter of administration, in what circumstances it can be granted, in what circumstances probate is mandatory. So all those confusions were there, and I have just recently done research on this, and from bare reading of the text, I have not examined the judgments on these particular sections, but bare reading of the text of the legislation or particular provision. These are my personal views, which you must remember, and I hope that whatever information I have shared today will be helpful to you in understanding the concept what we have discussed today. And I am thankful to Mr. Vikas Chatrat for giving this opportunity to share my views on these very complex topics today. and I'm certain that it will be useful to everyone. Thank you very much.
You have actually hammered the point in the right perspective. I'm quite sure that those who watch it will have a lot of brownie points for understanding. And you have rightly said that there's quite less litigation in the courts. It is basically just like a sculptor. You just have to chisel out the stone in the right perspective so that people can understand how things go out. There are two questions on the chat box. If a person stays in Mumbai,
Yes.
he is having a property in Mumbai as well as in Hyderabad. So,
Right.
this case, he has a property in the name of father of the legal heir. Both mother and father has died. This, in case, Bombay High Court can be approached in this case, even though the property is in Hyderabad.
Hyderabad. Will is made where?
He's silent on that. He's basically on that.
So ultimately, you will have to refer to section 57A and B. If the person is domiciled in this, and if the properties or the properties are situated in Bombay, Madras, or Kolkata, it would be governed by section 57 clause A and B, read with section 213. But again, I must remind that the question of obtaining probate will arise when you want to establish your right in the court of law as a legatee or the executor. You can convince the authority that why are you insisting for, there is no dispute among the legal, at best you can say, please bring the no objection from other legal heirs. But I am not supposed to go to court if there is no dispute. And once you go to the court, you will have to pay court fees, because court fees originally was ad valorem. So suppose the property value is running into 8 crore, it was originally 8% of the value of the property. So, but ultimately, when the Supreme Court was confronted with the issue that in other suits, the maximum court fee is 75,000 or 15,000 originally. How can there be higher court fees ad valorem basis in respect of probate or letter of administration? So, Supreme Court struck down the provisions, such provisions where ad valorem court fees was prescribed under the Court Fees Act. So that was a judgment in Ashwatha Narayan versus, I think, state of Kerala or Karnataka, which is reported in AI 1986, Supreme Court page 100. So I'm not sure what are the facts of the person who has asked me the question. But if he has a property in Bombay and Hyderabad, as I said, that probate would usually apply within the state. So he will have to seek probate in respect of the property situated in Bombay. But if he wants the applicability of the probate or letter of administration beyond the state of Maharashtra, then he will have to write specifically in the petition for probate that he wants applicability of the certificate not confined to the state of Maharashtra but beyond it.
Next question is: a will is executed without naming the executor in it. Legatee does not want to move to the court for letter of administration. Can any other person move the court for letter of administration even though he's not a legal heir?
Yes, any qualified legal heir would be entitled to move, and in absence thereof, even creditor is entitled to move for letter of administration. So one has to find out that who are the legal heirs. Only legatee is there, one single legatee is there. If he is unwilling to go for the letter of administration, any other qualified person can also, means legally entitled, or a creditor can also apply for the letter of administration. That is the provision under the Indian Succession Act.
Last question is: person dies intestate, leaving behind two own brothers. Deceased was unmarried, having his EPF and other gratuity funds in his name. Whether it is better to file letter of administration or succession certificate?
This would fall within the definition of security as contemplated in Part 10 of the Indian Succession Act. So if you want a summary procedure and if you want to pay less court fees, then you will have to just simply in the application for succession certificate, you will have to state that this is the value. So court fees would be charged accordingly. And if it's a non-contentious case, then it will be granted immediately, even in case contentious case. So for a succession certificate, court is not precluded from granting succession certificate, because Section 387 clearly says that merely because you are holder of the succession certificate, you are not the owner. Your liability to pay to the other legal heirs is not wiped out.
In certain cases, we've also seen that under the civil services rules also they laid down what is the process. Though it is a brother, like in Punjab civil services rules, there is a rule of 6.16. It bifurcates how the property has to be dealt with.
Actually, see, when somebody dies intestate, inheritance would be governed if he is a Hindu Succession Act. So as per the provisions of Section 6 or 8, whatever may be, I think Section 8, when a male Hindu dies intestate, then the rules of inheritance are given, who is class 1 heir, who is class 2 heir. So property has to be distributed in accordance with the provisions of Hindu Succession Act.
Now, what are the functions of the holder of letter of administrator?
So there is a elaborate provisions made under the Indian Succession Act. Most important function is to distribute and administer the properties of the deceased to the persons who are lawfully entitled to get it. And he has to report to the court about it. Sometimes in a given case, court can ask for bond also, that if you are seeking letter of administration, you will be distributing the property in accordance with the rule of inheritance. Please execute a particular bond also. So there is a duty to administer and report to the court that the properties have been distributed among the persons who are legally entitled to inherit. And as I said, that assent is also required to be given. Only upon granting assent by administrator and the executor, the executorship and administratorship is divested. Otherwise, they are responsible until they give assent under Section 332 or 333.
Another question. Whether letter of administration, succession certificate, probate come at one place?
I did not get you. Please repeat it.
Whether letter of administration, succession certificate, and probate come at one place?
Come at one place.
Probably he wants to say whether they are interchangeable.
They are interchangeable.
Probably it seems so.
No. See, as I said, probate can be granted to executor of a will. Letter of administration can be granted in the case of intestacy also, or in the case where there is no executor under the will. So letter of administration with annexed will be granted when there is a testamentary succession. Intestate succession, it would be governed under Section 218, which says that letter of administration can be granted to any of the qualified legal heir.
So, thank you, Mr. Pandya, for sharing your knowledge. This 1 hour of knowledge is actually a capsule of the entire perspective of this thing. And do stay connected with us on Sunday, where we discuss 50 years of emergency by HRS Raghavendran, senior advocate from Supreme Court. Thank you, everyone. Stay safe, stay blessed. Namaskar.
Namaskar. Thank you very much.